Hello everyone and welcome to the weekly video on Module 2. And in this module we're focusing on the way in which law and lawyers use information. And it has some of its particular own quirks that are different, and one thing we can really contrast it to is the way, for instance, a scientist uses knowledge. Because law is an authoritarian system of knowledge, which doesn't mean it's necessarily authoritarian in a bad way, but it's based on authority. The validity of any particular proposition in law comes from who said it. So in terms of Parliament, in terms of legislation, it's the authority of Parliament as a sovereign body. They have the authority to say this is the law, this isn't the law. In terms of the common law, it's the authority of judges. So I can say, I think that the decision in this case was completely wrong, it was decided on the wrong reasons, and that might be persuasive a little bit in the scheme of things, but if another judge says it, that has weight, whereas what I say doesn't have weight. So that's one of the first things to get your head around, is that in terms of what is law and what isn't, we've got that sense of authority. Now that doesn't mean that everyone else's opinion is utterly irrelevant, because we have the secondary sources and we have all the debates that go on in the literature, in the journals and so on. That's all relevant. But it means in the courtroom, we very rarely have reference to other academic sources, research and so on. And that does end up with very strange situations at times. So, for instance, in criminal sentencing, judges will frequently make reference to crime rates or whatever without any requirement to actually refer to the data that we actually have. So criminologists particularly are going to find that interesting, that a judge can say, oh, because the crime's out of control at the moment, I'm going to throw out a very harsh penalty, whereas the stats may actually show that crime is reducing. And this is one of the problems in the system, because there is, yes, a lot of people are saying that judges should pay more attention to this information that's out there. But then there's a question of, where do you stop? And is a judge ever going to be able to do their job if they have to spend their time consulting all the different sources as well? So that's an interesting issue, and I know this is kind of an abstract way of getting into the topic, because the topic itself this week is quite concrete, and it's quite focused on the nitty-gritty of how you find things, how you source them, how you reference them. But I think it's important to start getting that difference into your head, that when a judge makes a decision, it isn't because this is what they think is right or this is what they think is just, and it is not based on intuition, sense of justice or anything else. It's based on legal argument, and legal argument comes out of those authorities and what the law actually has to say. And that can be quite a surprise, particularly if we've been raised on Hollywood movies where the hero stomps up and down the courtroom and appeals to justice and everyone has tears in their eyes. It can be quite a surprise to actually see a court case and to find out that it actually turns on these very highly abstract theories and principles and precedents and pieces of legislation, and you never ever appeal to anyone's emotions. Very, very rarely. There's some exceptions, there's always an exception, but legal process is surprisingly enough, the movies lie to us. Who would have thought? All right, and then that is, I think, getting started as a scholar in this area, as you are doing, is important to keep in mind, because particularly I know a few of you have previous qualifications, and some of you are studying another area, and we've got a few psychologists, hello psychologists, who are curious as to how psychological information is different from legal information. And when it boils down to it, information from other disciplines only gets brought in as expert testimony, and that's under very, very narrow circumstances. And that itself is kind of problematic, because as you can guess, there are experts who are plaintiff experts and there are defendants experts. And if there's a medical injury, there'll be a whole lot of doctors who will always say it's not caused by the workplace. So say someone's injured at work, and you'll know that these doctors will always say the workplace is not culpable, and there'll be a whole lot of other doctors who always come along and say, oh, the workplace is culpable. So there's a real cynicism within law about those expert knowledges, because they're seen as being very much aligned with whoever hires you to be an expert. And quite often that's why law likes to keep as much of the other disciplines out of what it does. All right, but yes, that does become an issue if you are educated in the idea of science, and the idea of science is, you create propositions, hypotheses, and the person with the best proof is the one who wins. So, if you're looking at physics, it doesn't matter if the person who solves a physics problem is a well-respected, well-regarded professor or a street kid with a knack for physics. It's all in the proof of what you do, whereas law is very much about your status within the law and the legal establishment, and usually it's not even about being a respected professor. It's about whether you're a judge or not, and that's why law is inherently conservative. And I mean conservative in that traditional sense, not in the crazy right-wing meaning of conservative that's used in America, but basically that law stabilizes a system. It stabilizes a set of knowledge and tries to keep things the same. And that can be good when you're facing a period of crisis. It can be nice to have reliable things in law, for instance, ideas of rights. Rights are very conservative, but I'd really like to have them. And they also can then be used in a progressive way to be expanded where they're denied to people. But law is not necessarily good for creating new rights, and that's where we have the idea of why legislation is important and why Parliament is important to push those agendas. Anyway, there's a whole lot of debates we're going to come back into about activist courts and the role of the law and everything going forward. You're right at the very start of your journey now. So we're really looking at when you're making a legal argument, when you see a legal problem, because this is what we're all about here. You've got a legal problem. What do you go to? Do you go to Google? No. Do you go to the best scientific minds in the field? No. You go to what the law already says. All right. What's the next point I wanted to make? The next point I would make very quickly was that law evolves as well, and it evolves slowly. And this is part of the conservative nature of law. Unless you have a dramatic new act introduced that entirely changes things, most law happens like choral forming. Over years, judges will make slightly different decisions, and that'll steer the law in a certain direction. Legislation will get little amendments here and there. And again, that is a strength and weakness of law. It's very, very stabilizing. It's good in terms of predicting what's going to happen next, but if you want to see abrupt change, law is usually not the institution, despite the mythology that we get that, court cases change everything. They very seldom do. They usually make little baby steps along the way. Anyway, these big ideas are discussed a little bit more in the primer, which is, I think, in the first week of materials, which I wrote as a kind of a friendly introduction to using legal sources. Nicola's created the study guide for this week, which is much more in depth and it's much more focused. So it gets to the nitty gritty, whereas the primer I wrote was just to try and get the main ideas in your head, so we could move on to this. But hopefully the two of those things work together. All right. So the first, I'll go through the sections of the study guide and give you a brief overview of what's in there. All the stuff this week, the best way to learn is by experimenting. To learn by doing. So you can read the stuff on the page and your head will start swimming after a while and it's like, oh, I don't know, whatever. Get in there and look and look at the sources that the workbook suggests, the study guide suggests you go out, experiment, play around with them, target things that are wrong, and then come back to us and come back to teams and ask questions. So don't just say, I don't understand this, and go to teams and go, I don't understand any of this. Try it. Try it and see, and then find out more about why you don't understand it. And you might find that it's more intuitive than you think. So let's look at legislation, cases, legal encyclopedias, and then there's a section in there on integrity and referencing. So that's what we're going to look at in this module. First, legislation. If you understand how laws are made, and we've got some references earlier into if you're not really familiar with the Australian parliamentary system, check those out and find out more about them. If you're already familiar with it, I'm not going to go over that in depth. The one thing that most people don't know a lot about is delegated legislation or regulations. And this is a fascinating area, and that's where the law empowers so the legislation made by Parliament delegates the power to make subtle changes to the law to an administrative body, to an unelected body. An example I always use of this is the dog catcher. You know, your parliament can create create the role of a dog catcher, give the dog catcher power to catch dogs, but they can create regulations by leaving wiggle room, and they can say in the legislation, the original legislation, and the dog catcher will make regulations as to what hours they keep and what types of dogs and where they keep them. And then, because that original legislation empowers that bureaucratic person or administrative body to create law, they can create law within the scope of that delegated power. And because it's extremely costly and slow to actually change things, we find that quite often this form of lawmaking is useful for when things are going to change. So good ones are fines. You know, the dog catcher is allowed to set what the fines are for having a wandering dog, and then the dog catcher can then publish each year what their fines are. And now we tend to use penalty units, and probably not worth talking about that now, but the government centrally sets a penalty unit, and then they can just change the penalty unit each year. So it's like 5 penalty units for this, 2 penalty units for that. And so instead of having to change every piece of legislation, they change the penalty units regulation, and that puts the prices up of everything. I hope that makes sense, but I don't want to get bogged down in that as a bit of a detail. So yes, delegated legislation, that's worth knowing about. It's worth knowing that basically we can make laws that have wiggle room. There's still a formal process. You still have to publish the changes. They still have to have the power delegated, but it is more efficient to do that than to have the legislation changed every time. Now, if you're a law student, you'll be excited to know that there's a whole body of law that deals with what happens if something goes wrong with that delegation of power. It's called administrative law. I think it's fascinating. Some people moan about administrative law, but I think it's actually fascinating because it's about the control of government, and it's about the way in which, you know, you give the dog catcher powers to catch dogs, and the dog catcher decides they're going to go catch children and put the children in the pound as well. And you say, oh, whoa, that is an excessive power. You were never given that power in the first place. And it's an area of law and legal review that is growing dramatically. And as a society, we're doing more and more by regulation, less and less by legislation. So that's a bit of a long description of delegated legislation, but I think it's important. And sometimes they're called bylaws. So councils have bylaws. They don't create acts. They create bylaws because councils look like government, but they're not really government. They're actually an administrative body. Anyway. What else did I have to say? A general introduction to the databases. Now, legislation is all in free databases, and that's under the principle of open government that, you know, people should have access to the laws. That you can't really have a fair democracy where people don't get free access to see what the laws are. That's a reasonably recent development, of course, because before the internet, there was no practical way to get those laws out to people. So when I started studying, you had to go to the government printer and buy copies of legislation. And they were, you know, they were not supposed to make profits on it, but it might cost you $30 to buy an act because you had to actually buy it physically in a paper copy. So one of the great things about the internet and projects like OSLI has been that we've seen the rise of that open law, and in the area of legislation, that's been the most dramatic in terms of giving people access via OSLI, via the government websites, to the authorised acts. But that's not uniform across the board. We had a bit of a struggle when in terms of case law, which we're going to talk about next, because the right to publish and make profit off of cases in the reports was basically sold and licensed by government, and the people who owned those rights were not very happy with the idea of those cases going online for free. And we ended up in a very strange situation where the actual text of the judgments are free, but anything that the publisher adds, including page numbers, is not free. So you're authorised versus there's a whole era of acts where you can get free acts of cases where you can get the text of the cases fine, but you can't get the page numbers because they are things that the publishers added onto them. So let's move on to those cases. So originally, again, pre-internet, you had authorized report series, licensed, people made money out of them. What they added, apart from page numbers, were things like head notes. And a head note is a quick summary of the case. It's not created by the judges. It's not authorised by the courts. It's only authorised by the reports. But it is very handy to actually be able to look at that summary. And that's one of the things why we're directing you to the authorised reports for cases, rather than just saying look at OSLI or whatever, is that being able to access those head notes is very, very useful. And because of the problem with page numbers, the courts are now developing their own page numbering system to make a citation easier. Because what actually happened at the time when they, it sounds silly, oh, you can't use our page numbers, but it actually made it impossible to cite principles out of cases without you accessing the paid version. Because you'd say, oh, it's the case of Smith and Jones at page 37. So you needed those page numbers, but the free publishers like OSLI weren't allowed to reproduce those page numbers. So on it goes. But today the courts are developing their own page numbering system. But yes, why use authorised reports when it's free on OSLI? Because sometimes you want to check that head note and you want to get that summary before you read in depth, just to make sure you've got the right case and you're on the right track. What else to say about cases? Citation, learning how to do that properly is important, and it was actually a few people requested that in the check-in for this week. So, yay, it's coming up this week if you're someone who was hanging out to learn about the citations and what those letters after cases means, and they refer to those authorised report series most often, until you hit the internet, really. Also, case citators are in there, or shepherdization if you're in the United States. And these are services, again, they're fee-paying services where they keep lists of cases, later on cases, that use those earlier cases. So obviously when you print a case, you can't say how it's going to be used in the future. You can only put in its relationship to previous cases. A case citator, and OSLI does this as well for free, will say later cases that refer to this are blah, blah, and blah. So that's extremely useful, so you can actually see what's happened afterwards and to stay up to date. So yeah, OSLI does it for free. There are commercial services. Again, as a student, we buy subscriptions for you at extremely high cost. So while you're a student, you might as well use those. Because once you get out into the world, you'll lose access to them. And it's amazing, even a lot of the big law firms don't buy subscriptions to these things because they're so expensive. And I've heard of many situations where law firms are they've got students working for them as clerks or legal secretaries, and they're using their student logins to get into the university's access rather than pay for it themselves, which of course is a terribly wrong thing to do. It's like stealing Netflix, except if Netflix costs you tens of thousands of dollars a month to access, which fortunately it doesn't. So anyway, case citators, that's important to know. You need to know not only what happened before, but happened afterwards. Legal encyclopedias. The next section's about encyclopedias and journals. Encyclopedias are an interesting thing. The encyclopedias themselves are quite difficult to master. Don't let me put you off, because they're worthwhile learning how to master. But they're based on the old pre-internet technology, and they haven't really been reconceptualized from a modern interface. For various reasons. So a lot of people hit the legal encyclopedias and are just overwhelmed by the difficulty of using them. And my only advice there is experiment and persist, and particularly do that while you're a student, because again, once you get out in the wild world, you'll lose access to those things, and it's worth knowing about them now and how you use them. Now, in terms of the role of an encyclopedia, which is a reference work, law textbooks actually take on a lot of that role themselves. And if you've studied anywhere before and you've now looked at law textbooks, you'll notice that they don't often work really like textbooks. They're more like reference books. And they break things down into topics, and here are all the cases, and here's the legislation. And they're less focused on teaching you stuff and more on recording information. So what you tend to do when you're solving a legal problem, is you'll start with the textbook that's in the area. You'll find out what was relevant up to the date the textbook was published, or the textbook was finished, because there's a big lag between it being published. And then you go to the legal encyclopedia to top up your knowledge of what's happened in the meantime. So please think of your textbooks as a form of encyclopedia as well. And also that might help you understand why we say, oh, it's a textbook, but it doesn't put much energy into actually teaching you anything as you would expect a textbook to do, that they're really these sort of dense reference works. And yeah, have a play with them. It's the only way you'll learn to use them. The one thing I think that's hardest to do with encyclopedias is you need to know the taxonomy they use before you can use them successfully. And sometimes if you just come at them cold, and I'll give you an example here. If you're trying to find out information about an agreement in a business, and there's an agreement and it's gone wrong, and you type business agreement, you're not going to be able to find very much as a layperson. However, if you know enough about contract law, hello law students, who many of you were studying at the time, you'll know that the correct terms are contract and acceptance, or contract and formation. And they may not be the intuitive words people are going to search for, but you know the right ways in which law classifies things into taxonomies, into areas and sub-areas and so forth. So part of the challenge for those encyclopedias is you kind of already need to know what you're looking for before you can find the answer. So, interesting times. And again, there's been an interesting argument, and that what a law degree does is not teaches you the law, but teaches you the structure of law. And I think that's really an interesting idea, that you're going to forget pretty much everything that you learn, lawyers and criminologists, as you go along. But what a degree teaches you is how to find information and the right framework to put that information into. And I think this is an excellent example of this, that if you're hit with legal problem solving in your professional world, you're not going to remember any of the information that you were given at undergraduate, and most of that will have changed by the time you have to apply it. But what you've got is the framework that you can use to understand it. Journals I'll deal with briefly. Journals are not as important in law as they are in other disciplines, such as criminology or psychology. They're still out there, but they are not often, usually not referred to in court. And often they're referred to in law reform. When governments look at changing the law, they'll look at the research base. So they are important in their own way, but not as important as they would be in another discipline. And as with other disciplines, we've got the same problem with knowledge locked behind paywalls, that a few publishing companies own all the rights to information which is produced by publicly funded research, and then people have to pay to access it. Again, as students, we pay exorbitant amounts for you to have access to those databases, but there are emergingly and stronger arguments that those things should be free, and this is more so in other disciplines. So when government-funded universities research cancer, and these companies can then sell that information about cancer, there's a very, very important cogent questions about, well, why do those companies get, just because they own the journals, why do they get to own access to that knowledge? So that's a side issue and one for another day, but I'm just flagging that as an emerging issue in knowledge generally. But for the moment, the university pays through the nose, so you guys can have access to those journals. So make the most of them while you can. And there are emerging new open journals that publish for everyone, so they're good as well. I'm going on a bit long, so let's jump to the next section. Integrity and referencing. You'll have already done the general module on student integrity. And a lot of that emphasizes it's the rules. You have to do it. It's academic honesty, and that's why you do it. I have a different take on that. I mean, I agree with that. I don't disagree with that. But for me, referencing is about juggling all these different opinions and different ideas and showing us that you know what you're doing. So you don't get any marks in academia for having the right answer, okay? You have marks for showing your working and how you get there. So for me, rather than having a negative approach to referencing and saying you've got to do it or you will be in trouble, I think it's much more important to say, no, what you're doing in referencing is actually constituting an argument, and you're showing not only I've read this, I understand it, and I've read this one and I can understand it. I can weigh these two things up and I can balance them, and then I can make an informed decision as to which one I agree with. So I think the process is much more complex than we often present it as, and it's something that, if you think about it in that way, it's not as much of a drag as I've got to do it because it's the rules. Now we're going to, I think, next module, next workshop, we've got an exercise that explores that idea a bit more in the light of critical thinking, and looks at that whole idea about an argument actually being about weaving these threads of argument, taking all these threads, putting them together and weaving them into something new that you've made. So we have to cover this stuff. We have to tell you, and particularly for the law students, that you can actually ruin your career by reasonably minor acts of plagiarism in first year. And it has happened to people where they haven't disclosed that they've gone for admission. It's been disclosed, it's come out later that they've been involved in plagiarism, and they've been struck off for it. So read that material. If you're a criminology student, you don't get struck off. There's no registration for criminologists. Yay. But for lawyers, this is something that's taken extremely seriously, and you need to be on top of that material. All right, so that's the content for this week. In terms of the challenge, we're using the idea of fact-checking as a context for exploring the idea of information and sourcing information. And we are hitting this all the time with misinformation in politics. And so we've got a politician, and I really don't care about, this being a conservative, radical, right-wing, left-wing, whatever politician. What it is someone who is just talking about a lot of things without actually referencing or sourcing where they've come from, and they're asserting facts without backing them up. So this exercise is about picking through that and saying, where should they have actually been able to provide a reference or some form of support for that opinion, and looking for where you find that. So that's an easier way to approach the problem than for me to say, write a paragraph and put proper fact checking in, because then you've got a blank page. What do you do about it? But if I give you a bad example and you could work through the bad example, that's something that you can get your teeth into. So I've used that a lot in the past, different versions of this, and I think it'll be really useful. So we're going to do that in class in week 2, and we'll be doing it in small groups, but we'll also be talking about and having a bit of a look using screen share about how you find these different access points in the library. And finally, what I want to do is a close the loop activity for this week, which is I have a look at the your check-in exercises, and thank you all everyone who contributed. It's really, as I said, really useful to get that feedback, and then I close the loop in these videos and say, yeah, this is my response to it. So the first question was about your reasons for study, and a lot of those were very, very pragmatic. It's always interesting to see the different opinions, the people who are doing it as a core unit because part of their degree, and people who honestly said, yep, I'm doing it because I have to do it, and often gave me a little smiley face to acknowledge the honesty of that. But there are also people who are from outside the discipline, people who don't have to do it, who are studying it because they think they're interesting. They think the topic is interesting. They're probably interesting as well. I won't rule that out. So yeah, it's good to see that diversity, and it's also good to have a strong motivation to study every unit, even if it is one you're doing it because you have to do it. If you can actually locate, this is why I'm doing this above and beyond why I have to do it, it makes your life a lot easier. If you can find that one thing that's interesting and go, yeah, okay, this is why I'm doing it. Really good for motivation, which is an important thing. A lot of people mentioned criminal law, possibly because there's a lot of criminologists in the area. One of the I guess depressing things for a lot of people who study law is that there's only one criminal law unit in the entire degree. And often people who have a desire to get into criminal law find they spend almost their entire degree looking at land law and civil law and contract law and corporations law, and they don't really get to focus on crime as much. So just acknowledging that, that if you are someone who has a really strong interest in criminal law, the authorised Australian law degree doesn't give you much of a chance to explore that. But hey, let's go into commercial mode. You can always do a change to a double degree of law and criminology, and then you can do lots of criminology units. And this is a shameless plug, but that's the way I went. I did undergraduate law, and then I switched to a master's in criminology. But if I had had the opportunity when I started to do that double degree, that's probably the way I would have gone, because I was in that category of people who criminal law was all I was interested in, not knowing where I would end up, and was disappointed that, is this all we get? But you do have other options, and you can always then come back later and do more study if you want to. And if you want to transfer, there are processes for it, so don't think you're locked into your degree as it stands at the moment. So I'll take off my advertising head of course of criminology hat there, but I just think it's important for you guys to know. All right. Next thing was the map. Our apologies, I didn't set the preferences right, so you couldn't edit the map, but you can get back into it even if you've done the survey and pop your pin in where you are in Australia. It's really interesting to see where everyone is. All up the Queensland coast is very interesting. I suppose there's not much inland for people where people live, for there to be much that's inland, and every state except for Tasmania and the two territories. So we're going to have to find some people in Tasmania, and if you're in Tasmania, get into the map and put yourself down there so we can see where you are. That stuff's not really all that important in the scheme of things, but it does give me a great feeling when I see how diverse we are and how widespread we are across Australia, because I find that really fascinating. All right. In terms of the one thing that you want more information on, a lot of the stuff was nuts and bolts of things that are coming up in the next few weeks, which is great because you're going to get what you're looking for, and it means we've just constructed the course in the right way. So a lot of people said, I really want to know more about citing cases and what that means. Well, we do that this week. That's good. You're going to get that. You're going to get that done. So that was very promising. A lot of people talked about, or a few people talked about, the idea of reflection and the structure of reflection. I don't want to talk too much more about that now, except that it's a conversation we can keep going. In terms of marking those workbooks, it's really a pass-fail mark, realistically. It's, we're not going to get into the subtle shades of your reflection wasn't quite this or quite that. And I find if I talk too much about assessment at the start, people who are confused just get more confused. And every time I try and clarify it, people just get, but what about this and what about that? So have a go at the exercise, have a go at the process, have a look at the resources we've put there on reflection. But ultimately, it's just about showing what you've learned. I think that's the simplest way of putting it. And it's not that kind of, I had a great time this week and I had made some new friends or anything like that. It's not that lightweight surface stuff. It's coming into this week, I didn't know how to do this, and this is what I learnt from it, or this is what I didn't learn from it, and that's important too. I thought I would learn how to do this, but I didn't learn how to do this, and that's important feedback for us as well to know. Okay, some people struggled with this concept. Let's improve how we do that. So there were questions about how personal reflection should be. Yes, it is personal, but it is not that kind of, I had a lovely day today and the sun was shining and I was sitting, which is nice if you have a lovely day. But reflection is that more about that you're learning how to use the seeds, use them as a starting point, but you don't have to use them. Occasionally, workbooks will have a direction to say in your reflection do this. Not that often, but sometimes they will, and follow those. But generally those seeds are just to help you over that hump when you've got a blank page and you really don't know what to write. Now, some other people had questions around definitions of terms and concepts. We will be doing more of that stuff, but feel free to pop that stuff into Teams. Hey, I might do that now. I might create a terms and definitions channel, and that's going to be easy to find things. So if you go, I keep hitting this obit addictor thing, and I don't know what it is, which we will explain to you. But you can pop it in there, and someone will answer you. And if I don't answer you straight away, someone else will get to you and answer that. So I will make sure we put that channel may be useful for people who are struggling with some of the complex terms and the stuff that we, how much can we introduce in the first week without totally swamping everyone. When you post stuff in Teams, make sure you @ me. You put @ before my name, and that will give me an alert in Teams that draws me straight to. I scan Teams all the time, but I don't read absolutely everything that goes through. So that @ing is really, really useful when you need my attention on something. But every time it's happened so far, someone else has answered the question for me before I've gotten to it. So yay, mind sharing through the whole group and collective thinking and everything else. The last thing I wanted to mention about Teams is that I have figured out how to create private channels. So if you've got a study group and you want to be able to use all the Teams functions, including video conferencing, so you can share files. There's a file share system. There's all sorts of other gadgets and widgets you can put in. You can do video meetings. You can text each other, message each other. You can have your own. All that stuff. I can create a private channel, and I can delegate it to someone as a leader, and then they can add everyone to that they want to that group. So probably the best way to do that is to send me a chat message in Teams and to say, please create me a private channel. And if you've already got students' names who you want, I can add them in as well. But I will make you the owner of the team, which means you can add people to it. So that's there, and that's a very useful tool to be able to keep those study groups together and to use all those Teams functions. All right, that's probably been a huge long talk. Hope you haven't all switched off after 10 minutes and gotten bored. So I will close off now and see you in class next week.